more familiar with it. I think that is moot now by the answer of the state and by things we have learned since the motion was filed.
Right.
So I believe that the motion to you is now withdrawn.
Then it is withdrawn. And it's ordered withdrawn from the record.
And, Your Honor, just for the record, we have filed a formal motion to seal the exhibit by the court. I know the court has already done so, but it was informal at that time. And in spite of the fact that the motion's been withdrawn, that's still out there, and I know the media got it, and I think that's a real problem. And so we just did go ahead and file that as well.
And also, what I meant by withdrawn is it's moot. We don't need to present it in our hearing.
Okay, I understand. And Ms. Johnson, I understand there is already an order of sealing that's been entered, correct?
Yes, ma'am.
Okay. So she's already taken care of that. Okay, on the motion to enforce the sentencing agreement, let's take that one up first. And to disclose specific terms of the settlement agreement, I think that one may be moot also, correct? The specific terms of the agreement in the probate matter, that is moot?
Okay, Your Honor, they provided us with what they purport to be the agreement.
Right.
But it has come straight from Shannon Nugent, apparently, and the signature pages do not indicate that it was not moved from another one. And I would feel more comfortable with an official version that came from a lawyer.
Okay. I haven't seen the document you're talking about, but
Your Honor, Ms. Nugent is a lawyer.
okay, she is an attorney.
She's a party also.
She's not a party. The state of Texas is a party.
Well, I mean in the probate matter.
She's a biased party, Your Honor.
Well, okay. What is the document? Describe the document.
The document lays out how the sisters of the decedent settled a will contest with the son of the decedent and his children, and it has information regarding some affidavits that were irregularly obtained.
Right.
And it also contains information that claims that there was no knowledge of the signature of the 1987 will, and that is the will that I have recently found signed in the discovery of the AG's office. And so those are going to be material in our defense, and I am much more comfortable with something straight from the court or from one of the lawyers in that case. And I have to tell you, another irregularity is that Mrs. Rhodes cannot obtain this because her lawyer apparently destroyed all of her records.
Is Miss Rhodes, is she a potential witness here?
Yes.
Okay. So she can authenticate any document, can she not?
I do not know if her own attorney reviewed this document properly with her.
Okay. If there is another document that is it file marked? Do you have something that's file marked?
No, Your Honor.
If there is a file marked copy of this document, then supplement discovery and give it to the defense.
I don't have a file mark copy, Your Honor.
Okay.
I've given them what we have.
Okay, Ms. Nugent is raising her hand, so she is an officer of the court. If you'd like to stand, Ms. Nugent.
It's my understanding that the file mark was on the order to approve the settlement agreement, and the settlement agreement was attached as an exhibit, and I gave them the whole thing together.
Your Honor, does that mean that she obtained this from the court record along with the file marked exhibit?
Just a yes or no answer, Ms. Nugent, is fine.
I did not know.
Okay, you don't know.
Well, I obtained it from the attorneys.
If there's another one that you can supplement that has the file mark, do so. It sounds like to me there may or may not be a way to get that. I just don't know. But you have the document that you need.
We have what we think is the document. I think our original request was to ask that you ordered the probate judge, told that this is a,
Right, that was the original request.
yes. So I think we should go ahead and do that, and we can compare that with what Ms. Nugent has given the DA's of the prosecutor's office.
Objection from the state about that?
Your Honor, that's obviously within the discretion of the court. I'm not sure that the court necessarily has the jurisdiction to order another judge to turn something over.
I mean, I can sign an order, and it's up to them whether they want to agree to do that or not. I mean, that's not my...
The document that we provided, Your Honor, is referenced in the file mark copy of the settlement. It's the settlement agreement. It has the signatures of each individual on it. Anytime we give them a document discovery, they're welcome to say, well, that may not be accurate. They can say that. But there's no evidence that that is not accurate, and we've given that to them in an attempt to facilitate things. And I leave it to the discretion of the court.
And I would ask that you do enter the order, and then we can take it up with the probate judge.
Do you have an order? If somebody could find one,
Can we draw it up?
I'll let Ms. Johnson see if she can locate that particular order.
The order that the copy that I gave you, Judge.
Would be on the motion to disclose specific terms in cause number 8756, correct?
Yes, Your Honor.
And that was in Panola County.
Yes, sir.
And that order is entered. Okay, now on the, let's move to this motion to enforce the settlement agreement filed by the defense. And I'm telling you, we had a final pretrial on March 16th. And I was hoping that was what it was, because that's what we called it, was final hearing. And now, this past week, I've had a mountain of new things come up. And I know last minute, getting ready for trial, that happens. I'm not trying to, I'm not getting on to you. It's just, at some point, we gotta move on to jury selection, and all these motions are becoming somewhat of a problem. But we will take them in due course. Now, your motion to enforce the settlement of the sentencing agreement, this is a very complicated matter. I have read all of your papers. I'll certainly let you argue your motion and why we need to do this at this juncture. The state can respond. They have already filed a response, which I have also read. So, Mr. Garrett, you will.
Before we begin, can we approach the court for just a moment?
Sure.
Would you like this on the record? I don't think it needs to be on the record.
I would prefer that it were on the record.
Okay, that's fine. Just put it on the record.
You know, the only concern I have.
I'm going to have to get one here then. I'm sorry.
There's a microphone here. We're just going to move this microphone for just a minute. Mr. Peace.
That meeting turned into I don't want to overstate it, but a very uncomfortable meeting. To the point that the elected district attorney decided, with this much vengeance against me by some of the relatives, that I might end up being a witness about what's going on. And so he filed a motion to withdraw, to recuse himself, and to turn the rest of the prosecution over to the Attorney General's office in this case. That all happened as a matter of course. And Judge, I believe you were the judge of some of those proceedings I'm talking about. And you're well aware of
All of them.
all of them. Okay. I think Judge Dickerson recused himself somewhere back.
He did.
So I'm talking to the choir, so to speak, because you probably have a good memory of this, and I wasn't here when that
Oh,
happened.
yeah. I've got a good memory of this.
Okay. So, so I had been hearing about this since maybe November of last year. And then from Ms. Cole.